module covers the U.S. legal system and procedures. We'll begin the module with a discussion of the structure of the U.S. court system. Courts in the U.S. can be classified several different ways: as trial courts or appellate courts, as federal courts or state courts, and they can have exclusive or concurrent jurisdiction over the cases that they hear. Trial courts are courts of original jurisdiction, meaning they're the first court to hear the dispute. This is where the plaintiff will file his or her lawsuit and where the trial will be heard. Appellate courts, on the other hand, hear appeals from the lower courts. Most jurisdictions in the U.S. will have one or more courts of appeals and a high appellate court known as the Supreme Court. Cases involving state law are heard in the state court system. Each county or circuit will have a trial court. In most states, the appeals from trial courts go to the state court of appeals. If a party wishes to then appeal that decision, he or she would go to the state Supreme Court. For example, in Georgia, each county has a superior court, which is the trial court. Appeals will go first to the Georgia Court of Appeals, and if necessary, to the Georgia Supreme Court. Cases involving federal law are usually heard in the federal court system, which consists of the U.S. district courts, several courts of appeals that are arranged in the circuits, and the U.S. Supreme Court. Federal courts also have the power to hear state law cases, but only where the plaintiff and defendant are from different states and the amount in controversy in the lawsuit exceeds $75,000. Some courts will have exclusive jurisdiction, meaning they are the only court that can hear that particular type of case. An example in the state court system is the probate court, which administers the estates of deceased persons. In the federal court system is the tax court and bankruptcy court that are both courts of exclusive jurisdiction over their cases. Other courts have concurrent jurisdiction, which means that more than one court could hear that particular type of case. We'll discuss the court systems in more detail as we go through this module. From there, we'll move to a study of civil procedure and process. Civil cases begin when a plaintiff files a complaint in a court. The complaint and a summons are then served on the defendant to give him notice of the lawsuit. From there, a variety of pretrial motions may be filed, discovery will be done, and if the case is not settled or dismissed, the civil trial will be held to determine the outcome of the case. There may be some post-trial motions or even an appeal of that decision to the higher court. After learning about civil procedure and process, we'll move on to a study of criminal process and procedures. Criminal cases have more stringent requirements because the defendant's liberty is at stake. The criminal process will vary somewhat depending whether the case involves a misdemeanor crime or a felony. Every criminal case will begin with an arrest. The defendant will be booked into custody, and then they are entitled to make an initial appearance before the judge, and they'll be told about the charges and his or her rights. The court may appoint an attorney if the defendant does not already have one. The judge may set bail. From there, if it's a misdemeanor, it's going to go to a preliminary hearing where the court will determine whether there's probable cause to support the charges that have been brought against the defendant. For felonies, the case will go before a grand jury, which may issue an indictment if it finds probable cause exists. If the judge or the grand jury finds there's probable cause, then that defendant is arraigned and he will go back to jail after he pleads either guilty or not guilty and wait for the trial. Or in many cases, the defendant may enter a plea bargain to avoid going to trial. Criminal trials can be bench trials or they can be jury trials depending on the severity of the crime and the defendant's wishes. After the trial, there may be post-trial motions or appeals similar to those in civil cases.